sat down again. We've got a good long topic break, a lot longer than we normally give you. And we're going to get started. The next session is on the Mental Capacity Act. And I can shout louder with the voice and noise you can make, you know. Right. Settle down now. Mental Capacity Act. You'll need to go around. The person we've got is not Matt Nichols. He is from the same firm and is even more knowledgeable. It's Emmett McGinn, who is going to give you all the facts you need to know about the Mental Capacity Act, which is really becoming more and more important in this day and age. So I give you Brian Jacobson.
Okay, thanks for that. I think the first thing that I want to do is just to outline what I'm going to briefly talk about. I'm going to talk for about 45 to 50 minutes hopefully, and then an opportunity to take some questions. I'm going to talk about what the Mental Capacity Act is, how you go about assessing capacity, and if a person lacks capacity, what actions can be done or should be done, really, when medical treatment is given in their best interests. Now, I suppose it should begin by asking yourself, well, why does this matter to you? Well, another way of thinking about the Mental Capacity Act is to think of it as the Making Decisions Act. And it's all about your patient's capacity to make decisions for themselves, whether they have that capacity, and if they don't, what should be done. It's absolutely key to the consent process, which is fundamental to everything that you do. And it's important to remember throughout, when I'm discussing the Mental Capacity Act and best interests, that compliance isn't the same thing as consent, and very often compliance can mask some of the key issues that you're going to need to think about whenever you're asking yourself, well, do I have this person's consent to proceed, or indeed, does this person have the ability to refuse consent to treatment? The implications for you are quite significant, and I think it's important to think about that, in that if you don't have consent in any circumstance, you went ahead and proceeded with medical treatment without consent, it can amount to an assault. That can be both criminal or civil trespass to the person. It could end with a negligence claim, potentially damages, and can also involve disciplinary or complaints proceedings. So it's important that you get mental capacity right. So what is mental capacity? The Act itself came into force in October of 2007, and it deals with whether a person has the ability, so capacity, to make decisions on their own behalf. It's important to continue to think about capacity as being decision and time specific. As lawyers, we often talk about it as being a functional test, and it's really important to remember that. The reason being is that very often one of the things that will cause me to have to speak to some of the clients that I have in a little more detail is that people will often say someone lacks capacity, and that's it. Well, really, there are very few people who lack capacity, full stop. It's capacity to decide what, capacity to do what. So in those circumstances, it's always a functional, specific test. Someone may have capacity, for example, to decide whether they want to go on holiday to the seaside or go to the countryside, but may not have capacity to decide how to invest their share portfolio or property that they own or whatever. So the test is very different, and it applies in different circumstances. It does include, obviously, decisions about medical treatment, but it's also day-to-day decisions, such as where to live, what to wear, what to eat even. And the Act sets out how you decide whether a person has capacity to make those decisions, and what you should be doing if that person is assessed as lacking capacity. So, basic principles. In law, there is a presumption that every person has capacity until it's established that they don't. Okay? So that should always be your starting point, that someone has capacity until it's demonstrated that they don't. You should also not treat someone as unable to make a decision unless all practicable steps have been taken to help that person make the decision. Again, we're going to see some examples of how that can be done, but it's very important to bear that in mind. The law has for a long time grappled with the issue of how you should decide when a person has capacity. The common law test, which has existed for a very long period of time and has evolved over time, was set out in the case of Rees C. And it says, is the person able to understand in simple language what treatment is proposed, understand the likely benefits and risks of the treatment, and very importantly, the consequences of not treating. So very often, one of the key issues in capacity is understanding that if you don't do anything, what the consequences will be, which flow from that. Can they retain information for long enough to weigh it in the balance and arrive at a decision? So that's what the courts have long since said constitutes the test of capacity. It's now been set out in the Act, as we've said, and a person lacks capacity if he is unable to make a decision for himself in relation to the matter because of an impairment or of a disturbance in the functioning of the mind or the brain. Okay? And that's actually the statutory language that's used to describe the capacity test. You'll often hear the phrase, whenever you speak to lawyers or if you read some of the legal opinions on this, you'll often hear the phrase unsoundness of mind, which effectively means the same thing. It's not really used by practitioners much anymore, but it is still used by the European Convention on Human Rights. It comes from Article 5. So it's important to remember that unsoundness of the mind, while it's not really used by practitioners, is still used by a lot of lawyers, and it's still used. It's important also to remember that capacity can be fluctuating. It can be temporary or permanent. One of the key things to think about there is that if you're going to be making a decision on somebody's behalf, if you've assessed that they lack capacity for whatever reason, maybe they've had an accident or whatever, and they need to decide whether or not they're going to renew a tenancy or something of that nature, the person who's going to make that decision on their behalf needs to think, well, will they recover their capacity in time to make that decision? Okay? So one of the things you've always got to think about is, well, is this temporary? Do I need to make this decision on this person's behalf, or can it wait until they regain capacity? And obviously, for fluctuating conditions, that would be a significant factor. So what's meant by unable to make a decision for him or herself? Well, Section 3 of the Act specifies what that is. It says a person's unable to make a decision for himself if he's unable, firstly, to understand information relevant to the decision, to retain that information, to use or weigh that information in the decision-making process, or to communicate his decision. Now, you can see that this is very similar to the approach that the courts have adopted in the Ray C case. What's important to remember is that if when you're asking these questions, does this person understand, can this person retain, can they weigh, can they communicate, if the answer to any of those is no, then that person lacks capacity. Okay, so it's not all four have to be present. It's simply if someone can't understand the information relevant to the decision, then they don't have capacity to make that decision. One of the key things I think it's worth pointing out that comes up a lot whenever I'm advising clients is communicating a decision. It's very rare that there would ever be someone who is able to understand, is able to retain the information, is able to weigh it, but can't communicate it. And the courts have been very critical of decision makers who have decided that someone can't communicate and therefore lacks capacity, particularly if there's an emphasis on verbal communication, because there are many, many ways in which someone may be able to communicate beyond verbal communication. So it should be relatively rare that you ever find yourself in a circumstance where you're finding that someone lacks capacity simply on the basis of a lack of ability to communicate. There are lots of things that can be done to facilitate communication, including using visual aids, etc., etc. So it's very important that you remember that communication should be a relatively rare occurrence in which you're saying someone lacks capacity. It's also relevant to think about how people communicate their views, not only on capacity, but also on best interests. So if you have a situation in which someone has been assessed as lacking capacity for whatever reason, and you taking the view that they can't communicate at all, it's going to be very difficult for you to subsequently demonstrate that in taking that decision on their behalf, you have taken into account their wishes and feelings. So it's very, very important, particularly, for example, with someone who suffers from dementia or someone of a similar condition. It's important to think about, well, how can you maximise their ability to communicate How can you try and ascertain whether they can communicate a decision? And even if they lack capacity, well then it's relevant for you to take into account their wishes and feelings whenever considering their best interests, which we'll come on to. Another key point to think about, and this is something that does affect those in the health sector much more than social care, is that competent adults can make unwise decisions, okay? As you can see from this gentleman in Pamplona. So you should not treat someone as lacking capacity just because their decision is unwise. And you're going to see from a case that was decided in 2002 why that's important. I suppose from a very fundamental perspective, if someone has capacity and they make a decision regarding their treatment, well that's it, isn't it really? It's an issue of personal autonomy in those circumstances. So it's important to bear this particular fact in mind. The test for capacity in practice. So in RE-MD in 1997, the question was refusal of a caesarean section due to a needle phobia. For this particular lady, the fear of needles was such that as soon as that needle was produced in the room, at the moment of panic, her fear dominated all. She simply could not make a decision in terms of the treatment. She simply said, I want to be out of this room, I need that needle to be taken away from me, I don't care what the consequences are. So the court held that at that moment, as soon as the needle was produced, she lacked capacity to be able to take that decision, and a decision had to be made in her best interest as to whether to receive that particular treatment or not, which in the event she did. So it's important that this person actually had capacity in virtually every other facet of life, except whenever someone was going to have to inject her with something. This is the case I just spoke about, which is remembering that a competent patient can refuse treatment. It's a very sad case actually, and very tragic. But in Ray B, a competent patient was held to be entitled to refuse artificial ventilation. Following hemorrhage of the spinal column, the patient became tetraplegic and was placed on a ventilator. The patient had been told by her clinical team that there was a possibility that her condition would get a great deal worse. And she had said, look, if I get to that stage, I would prefer not to be artificially ventilated. I would prefer it if my wish could be respected. And she was made aware by the clinical team that in the event that that occurred, she would almost certainly pass away within a short period of time. The clinical team were obviously very concerned and brought it to the court. And in the meantime continued with the artificial ventilation. The court asked for an independent psychiatric assessment, and it found that she did have capacity, but that despite this the treatment had continued, and the court held that this treatment was unlawful. She had claimed damages as well, but only nominal damages. She had sought a declaration from the court basically that the treatment was unlawful, and I think the damages amounted to only £1. She wasn't really seeking compensation for any of the treatment that she received. But the key point is that if somebody has capacity and they make a decision that is contrary to all the clinical advice that they've been given, and they're aware of the consequences of that, and you're satisfied that they understand, retain, weigh, and can communicate their decision, well then that's their decision, and there's no basis for going behind that. So, I did say that sometimes this is called the Making Decisions Act, and that's really what it is about. It's about helping that person to make a decision if at all possible. So the sorts of questions you should be asking yourself before you make a final determination as to whether somebody lacks capacity is, does the person have all the relevant information? Okay? I mean, with someone who has capacity, you would make sure as medical practitioners to have all information relevant to the decision. The same for someone who lacks capacity, they should provide with all that relevant information. Could the information be presented in a way that's easier for the person to understand? For example, a patient with a learning disability may find it easier to communicate using pictures. So you've got to demonstrate that you've utilised practicable steps to help them make the decision that they're being asked to make. One of the key things that comes across a lot, and again I mentioned dementia care, is that at other particular times of day when the person's understanding is better, very often in some of the cases that I get involved in where a family have made complaints or taken legal action against the trust or care home in question, have been on the basis that they've said, well, actually, if you'd come at 7:30 at night, you would have seen that Mum actually could make decisions. She could decide for herself. She was much better and more lucid than she was in the morning whenever you came and assessed her every few weeks, etc., etc. So it's very important to remember that actually, in terms of assisting someone to make decisions and ascertaining whether they have capacity, they may well be able to understand things better at certain times of day. And also, could a friend or relative help a person to understand the information and make a choice? And so very often it can be about putting people at ease, helping them adjust to the environment. And in those circumstances, communication might be it, and you might actually find that the information you're trying to communicate is being retained, whereas previously it wasn't. And this is an actual case study based on real circumstances. So Michael had a stroke, and he had been unwell and is admitted for tests involving a general anaesthetic. And he gets anxious whenever the doctor discusses this with him and repeatedly asks why he needs the general anaesthetic. The doctor is concerned that M does not seem to understand or remember what he's been told. The doctor consults M's wife. She explains that when he's away from his home and people he's familiar with, he becomes very anxious and begins to present very differently. The doctor discusses general anaesthetic again when M's wife is present. She explains that she'll be there when he wakes up and he will not need to stay in hospital for very long. And with the help of his wife, M is reassured and then demonstrates to the doctor that he understands what the doctor is saying, can retain that information, and can consent to the tests. So it's important to remember that those sorts of, they seem very straightforward, but they're easy to overlook. And those sorts of factors can be relevant to the issue of capacity. One of the things that keeps coming up, and as a lawyer, it's probably the thing I spend most of my time talking to clinicians about, is that the capacity assessment should be recorded in the patient's notes. Okay? It should be recorded why the person is deemed to lack capacity, because obviously people like me only get involved, when things go wrong, and that's normally some stage further down the line. And really, you don't want to be relying on your memory as to whether or not that person had capacity and how in-depth your capacity assessment was. And we'll see, there's another case study coming up that will explain why that's important. So you should be making a note of it for the reasons that I've given. It has to be remembered that it should be a proportionate capacity assessment. So the more significant the decision that you're being asked to take, or that person's being asked to take whenever you're assessing capacity, then the more extensive is going to be the assessment itself and presumably the note or record that you're going to make of it. So if someone is making a decision as to whether or not they would like to visit their aunt rather than their uncle one weekend, then that's probably not going to need a very extensive either assessment or note of that assessment. If it is as to whether or not to discontinue life-sustaining treatment, then obviously I think that most of us would agree that you would need to have quite a detailed note on what the outcome of that capacity assessment was and make sure that that record is kept and maintained. That note should include things that we just talked about. So the capacity test should talk about, were they able to understand the information? If not, why not? If they could, why? Were they able to retain the information? If not, why not? Could they weigh the information as part of the decision-making process? And could they communicate it? So all of those things should be dealt with whenever you're making a record of the capacity assessment. And like I said, it need not be onerous. You could literally, if it's a relatively straightforward decision on something that isn't gravely significant, then you could literally have one line saying that the person couldn't understand because they were asked X, Y, and Z, and were unable to retain, etc., etc. So, in terms of a very basic example that's given, this is given in actually the guidance for health and social care practitioners. Basically, this person on most days can make all basic decisions about daily living, washing, etc., etc. However, sometimes lack capacity to make the most basic decisions. the possible entry could read, at lunchtime today, lack capacity to decide what to eat, so a decision about this was made in best interest. At each meal time, we will assess capacity to decide what to eat. And that's a very simple, straightforward way of demonstrating that actually this person has thought about capacity and has thought about how to record it properly. So that's in essence the test of capacity under the Act. The majority of circumstances in which things go wrong is whenever the capacity assessment isn't very robust, or more often there's just simply no record of it. And in law particularly, whenever there's a dispute or an argument, normally if it isn't written down it didn't happen unless you can demonstrate that by some other means of evidence. But why put yourself in a position whereby you're going to have to justify it to a particular complainant or grievance whenever you include it in the notes. So if someone lacks capacity, well then what happens? So if you've done the assessment, they can't understand or they can't retain the information or a combination of those things. Well, the law says, and Section 4 of the Mental Capacity Act says that any act done or decision made on behalf of a person who lacks capacity must be done in that person's best interests. That principle applies whether the person is making decisions is a family carer, a paid carer, a worker or a healthcare professional, or indeed even lawyers acting on behalf of that person. But this is a key and fundamental principle of the Mental Capacity Act, and it has a very central relevance, much like the well-being of a child under the Children Act. Now, how do you assess best interest? Well, under the Mental Capacity Act, the decision maker must consider a number of things. Okay? Now, the list isn't exhaustive, but certainly these things, if you're going to demonstrate that you've looked at somebody's best interest properly, you will have considered these things as part of it. So the person's past wishes and feelings, and that's important in the context of what we talked about earlier. So someone might have difficulties in communicating, and that might indicate that that person doesn't have capacity. But even quite apart from that, it's going to be relevant to this consideration, i.e. the person's wishes and feelings are always relevant, even where you've assessed them as lacking capacity. And so communication is key to ensuring that you're going about trying to ascertain those wishes and feelings as best you can. What's also important is whether the person had any beliefs or values, religious, moral or cultural, that would influence the person if they did have capacity. Now, both of these things are actually, they don't determine the issue of best interest, but they are important. One particular example that I've been involved in and dealt with includes, for example, someone who lacked capacity as to whether or not to agree to a termination. And the termination is considered to be in her best interest by the entire clinical team. However, that person had previously expressed a view, a religious view, that actually they would be opposed to that. Now, that leads to a very, very difficult situation for a court to decide, which is the clinical team saying that actually it would be in her best interest, including the family, that it would be in her best interest to have a termination, but this woman categorically expressed the view, and that was the evidence before the court, that actually she would be against that decision. Ultimately, it was determined to be in her best interest to have the termination, even in spite of her religious views. So you can see how, in those circumstances, it's a very important consideration, but it will not always be the determinative factor. It's one factor to be weighed amongst many. One key issue that does come up that can be determinative in some circumstances, particularly when we're dealing with medical treatment, is advance directives. So an advance directive is where someone, at the time of having capacity, decides, look, if this happens to me at some future stage, a bit like in Ray MB, if I become tetraplegic, for example, etc., I would prefer that the artificial ventilation stop. That's what she said. There are some circumstances in which that would need to be honoured, like in Ray MB, but you need to be very careful with advance directives. Okay, so anytime you're dealing with an advance directive, you do need to consider it very carefully, because A, it needs to be valid, and B, it needs to be applicable. So what do I mean by valid? Well, by valid I mean that the person had to have had capacity when they made the advance directive. And there is a case called Ray E, from 2012, which involves, and a number of cases have involved severe anorexia nervosa. And they are very, very difficult cases from an advance directive perspective, in that the person in question was able to demonstrate that they understood the decision. They were able to retain all of the information that was provided. They could communicate their wishes quite clearly, saying that they don't want to be fed, and they simply do not want to receive artificial feeding or nutrition. But the key question is, can they weigh that information? So, and the court found in Ray E that actually this young lady, she's only 32 years old, this young lady's anorexia nervosa was so severe that she simply could not weigh any other factor. She couldn't weigh the risks, she couldn't weigh anything else against that. Her simple abiding thought constantly was that she did not want to put on weight. And the court held that she didn't have capacity, therefore, to decide whether or not to refuse artificial nutrition. She did make an advance directive a year before the decision needed to be taken, but the court said again, her condition was operating on her mind at that time. The advance directive wasn't valid because she lacked capacity, because she couldn't weigh the decision. So it's important that you do think about those sorts of things whenever you're talking about advance directives. The other key issue is it applicable? Well, by applicable I mean, can you demonstrate that that person has actually said that in these circumstances I want X to happen? It can't be a vague, let my mum decide, what happens to me, etc., etc. It has to actually address the issues that come up, i.e., if I end up in X situation, I do not want X to be provided to me. It should be as specific as that. There may be some circumstances in which it can be slightly vaguer, but obviously the more vague it gets, then the less you're going to be able to demonstrate that that advance decision is applicable to the decision you're being asked to take on that person's behalf. Okay? So the validity and applicability of advance directives are crucial and should always be borne in mind. I would always suggest that if you do have a particularly tricky scenario like that, you might want to talk with whatever legal team you have access to, because it is a very fraught area. You must always, whenever you're making a decision in somebody's best interest, you must always consult others on their behalf. Okay? In terms of who should be consulted, well, the person themselves should always be consulted, unless to do so would cause them physical or psychiatric harm. So it can't be distress. There's no basis for saying that they might be distressed by the discussion that you're going to have with them. It should be that actually the threshold of psychiatric or physical harm is reached. Anybody involved in their care should be consulted, whether family members, etc. It should also include consultation with anybody providing professional care to them. Nobody can consent or refuse on behalf of an incompetent adult. So there's no such thing as next of kin when it comes to mental capacity law. There is no special legal position that's held by the next of kin when it comes to mental capacity law. The decision maker is the clinician that's going to be making that decision on behalf of an incapacitated adult. The exception to that generally is either the court can make that decision, so the Court of Protection can make a decision on behalf of incapacitated adults, or that person might have a lasting power of attorney nominated on their behalf, and we're going to have a brief chat about that in a second, or the Court of Protection may have appointed a deputy. Okay? So there we go, next of kin. It has no real relevance or meaning in this context. And it's actually one of the things that I find whenever I'm advising either health professionals or social care professionals. One of the things they find is that families really get very upset about this, that they find out that actually, as a matter of law, they're not the ones that are going to be making the decisions unless they have a lasting power of attorney which is valid, or they've been appointed by the Court of Protection as a deputy for welfare issues. So it does come up quite a bit, and it's worthwhile being aware of it, that this next of kin point doesn't really mean anything. So you have to take into account the views of anybody named by the patient, okay, as a person to be consulted. anybody caring or anybody with lasting power of attorney. You also have an obligation, if there is an IMCA appointed, which is an independent mental capacity advocate. Okay, and the role of the IMCA is as a specific advocate who will only usually be, it says only involved, but will only usually be involved if there is no family or friends who can be consulted. The role of the IMCA is to try and advocate on behalf of the person who lacks capacity. In my view, actually, there are some circumstances in which an IMCA should always be employed, including the withdrawal of life-sustaining alternative nutrition and hydration. But in those circumstances, an IMCA should be involved. But it's only usually that you'll encounter an IMCA where someone doesn't have a family member that can act on their behalf or be consulted on their behalf about the decision. It's absolutely crucial that you understand that the IMCA is not the decision maker. The IMCA is just an advocate to speak up on behalf of the person who lacks capacity. They can raise issues, they can ask questions, etc., but ultimately the decision maker is going to be, if there is no lasting power of attorney for welfare and there is no deputy appointed by the court for welfare, well, the decision maker is going to be the clinician that's making decisions in respect of that person's treatment. So this is a very brief spin over lasting powers of attorney. Okay, introduced back in 2005. You probably maybe encounter something called an EPA, an enduring power of attorney. An enduring power of attorney was something that could be entered into up until lasting power of attorneys come into force, but you can't create them anymore, and therefore they're gradually withering away and being replaced by lasting powers of attorney. So an LPA can authorise the donee to make decisions about either that person who lacks capacity's welfare and or their property or affairs. And this is really important because very often you will find family members will say to you, I have lasting power of attorney or such and such has lasting power of attorney, and therefore I can make decisions as to whether mum should live in this care home or that care home, or whether mum should have this treatment or that treatment. And in reality, when you look at it, all they have is the power of attorney over that person's finances to make decisions about their money, not about their welfare. So it can include, a power of attorney can include refusal or consent to medical treatment, provided that an express provision is included to that effect. So again, it's important that actually, a lasting power of attorney that says mum can make all decisions on my behalf, is that really going to be something that you would feel comfortable with deciding whether or not that person should have life-sustaining treatment withdrawn from them? I think not. And in those circumstances, certainly I would be encouraging you to speak to a lawyer and or bring that sort of issue to the court in order to be sharing that particular risk. Lasting powers of attorney in relation to welfare, so a lasting power of attorney can take effect before the person lacks capacity in terms of welfare, or in terms of property and finances, I apologise. What can't happen is nobody can make decisions on behalf of a capacitated adult. So even if someone has signed a lasting power of attorney, given someone specific authority to be able to deal with welfare issues, it only becomes relevant whenever that person is assessed as lacking capacity. Nobody can make those decisions on that person's behalf until they're assessed as lacking capacity. And it must be registered with the Office of Public Guardian. Okay? So whenever you're dealing with this sort of issue and someone says they've got a lasting power of attorney, one of the things you can do is you can contact the Office of Public Guardian and ask. Email and say, is it possible to ascertain whether or not Mrs. X has a lasting power of attorney, and what does it cover? Does it cover the ability to make decisions regarding X treatment, dental treatment, whatever it happens to be? And the Office of Public Guardian will be able to inform you as to whether or not it does cover welfare issues or whether or not it just covers financial issues. Okay, so best interests, and this is from a real case again. P has severe learning disabilities and lives in a care home. Dental problems are causing him pain, but P often refuses to clean his teeth or open his mouth for carers to clean. He's experiencing significant dental pain. Staff suggest occasional general anaesthetic to allow a dentist to clean and treat. Mum suggests strong painkillers as an alternative, as this would be less stressful for all involved. While the carer's views are important, the mum's views are important, the decision must be taken in P's best interest, and the decision is going to be taken by the dentist, not by mum. The dentist considers the painkillers, mouthwashes, etc., so considers least restrictive options, and concludes that actually that wouldn't be sufficient to deal with it. So it would be in P's best interest for a proper investigation to be carried out under general anaesthetic, and options for future dental care can then be reviewed by the care team. Okay? So that's an actual scenario that has occurred. So it's important to remember who the decision maker is, and that so long as the decision maker is demonstrating that it's in that person's best interest, that actually that decision can then be taken, even where consultation with mum has indicated that mum doesn't agree with that decision. Where there may be a little bit of a grey area is where there is a dispute as to best interest, particularly between professionals. So if there had been two different clinical opinions in respect of what was the best way forward, then in those circumstances, it should be, there should be an effort to try and mediate that, to try and see whether or not an agreed way forward could be reached on best interest. But if best interest couldn't be decided upon, then eventually that's something that might well be referred to the Code of Protection to decide what's in that person's best interest, where there is a dispute as to whether it would be the former or latter course of action. Okay, so whenever you're assessing best interest, one of the key documents to look at is the Code of Practice on Mental Capacity. It is a huge document, but it is quite easy to read, and it's quite well referenced, and it's quite easy to get to the bit that you want to look at. The Mental Capacity Act is also very well written in a way that perhaps the Mental Health Act hasn't been, and it is very, very useful to refer to this. There is also, it's not up there, but there is also guidance from 2009 in relation to health and social care practitioners. It's only about 26 pages long. Obviously it doesn't go into the level of detail, but it's actually worth reading in order to begin to look over the other issues that we talked about. So, having looked at capacity, we saw the sort of 4-stage test for capacity, looked at what you need to be thinking about for best interests, we then come to a case study, which is a real case again. So an elderly lady with dementia, post-operation for a fractured neck femur, standard dose of heparin prescribed, 4-week post-operation dies of pulmonary embolism. On checking the drugs chart, it transpires that over half the doses of the medication were omitted by nursing staff, who noted on the notes that the patient was agitated and, quotation marks, refusing medication. So the question then is, could this lady refuse? What do we think? The first position that you would think about there as well, this lady is presumed to have consent until it's shown that she doesn't. The information we're provided with doesn't say whether or not a capacity assessment's been carried out, but one should have been carried out, obviously. If it was deemed that that lady did have capacity to make the decision as to whether to refuse that medication, wouldn't you, as the doctor or the clinician dealing with that, you would want to have a good note that demonstrates to anybody subsequently, when the person passes away, that actually that assessment of capacity was robust, that there was a record of it, and that actually it demonstrates that that person was able to take that decision. Otherwise you leave yourself at risk of a very serious complaint from the family and or negligence. If the decision had been, which actually transpired to be the case, that the person lacked capacity, then really there should have been a best interest decision taken on behalf of that lady. So the best interest decision would have had to have been, well, it's in her best interest to simply let her refuse the medication and run the risk of pulmonary embolism by not taking the medication, or more likely that actually it would be in her best interest to be moderately restrained and have that medication in order to avoid the scenario that did transpire. So you can see how, I hope in this case, how the very basic straightforward considerations of capacity, if you overlook even one or two of them, can lead to a very significant and serious consequence for the medical staff involved. Okay, are there any questions on those particular issues, or we can have questions at the end if you want to. If you've got a burning question, by all means, shout out.
Was it right for us to refuse a treatment in case people to accept it?
What's that, sorry?
You know the case we were discussing. Was it okay for the people to say, yes, okay,
Sorry.
She was just post-operative failure, so she might not be totally capable of saying anything, refuse or whatever.
Do you mean in the Hepburn case?
Yeah.
Yeah, I mean you would have to follow the process right through. So you would have to be absolutely clear. I mean the information that's given is very, very threadbare. But if you were the doctor that's dealing with that case, either if she was determined to have capacity, I think you would want to be able to point to a very clear record as to why it was said that she could understand, and in particular, if you're talking about refusal of medication, that she was able to weigh up the consequences of refusing to take that medication. So in those circumstances, you would want to be able to demonstrate that. If that person lacked capacity, then quite clearly there's a real difficulty here in that if they lack capacity, a best interest decision would have to be made, and it would be a very odd occurrence where it would be considered in somebody's best interest not to have medication prescribed and provided to them, even if moderate restraint had to be used. So I think it's important that those issues are worked through, and obviously it's a very open consideration given the fact that there's very little information, but it's to get you thinking about those circumstances in which actually it can go spectacularly wrong just by failing to consider one particular thing. Okay.
So somebody with dementia isn't automatically seen to be someone who lacks capacity?
100% not. The Mental Capacity Act makes it absolutely clear, I haven't really included that in there, but a person's diagnosis should never lead you to conclude that somebody has or has not got capacity. Even their physical appearance shouldn't lead you to conclude that they have or have not got capacity. It's absolutely critical. And I suppose if there is one consideration to take away from that, is that there may well be some medical conditions that most people would think actually this person would not have capacity when they're diagnosed with this particular condition, etc., etc. But the Mental Capacity Act is quite clear that actually a diagnosis shouldn't be used to determine that issue. It may well be that the person doesn't have capacity because they have very severe dementia and they're unable to, but you've still got to go through that process. You've still got to say, this person has severe dementia, they weren't able to understand the information, I tried alternative means of providing the information, they certainly weren't able to retain it. So in those circumstances, really, you shouldn't be relying on a diagnosis itself. You should be able to point to those different assessments of under the capacity test. Okay? And it does say explicitly, do not allow a particular diagnosis to determine that. Okay. So, do we have? Sorry. I probably should have asked. Is it okay for me to do this? It's okay.
I was going to ask about best interest meetings in the community. Obviously, they're more easily organised when you're a hospital doctor, and they're quite difficult as a GP when you're just on a visit.
Mm-hmm.
For example, I have a lady with very severe dementia in a care home. Assessed her capacity, wasn't capacitous. She clinically had a DVT, but me and the family and her care team felt that she wouldn't tolerate either investigation of or treatment of the DVT. So was that a best interest meeting, or does it need to be more formal than that?
It could be a best interest meeting, yes. I suppose, is there a record of it? Is the first thing I would ask.
Oh, it was a beautiful record.
Well, then you're my best friend. I think that's the key point, is that it needs to be proportionate, okay? So if in the circumstances there is absolutely no clinical dispute, best interest is relatively clear, you can point, literally in one line to say, spoke to daughter happy with, proposed course of action, spoke to care team happy with course of action, demonstrated consultation, demonstrated that actually just in one line said, attempted to discuss with patient XYZ for whatever reason couldn't understand, etc., etc., etc. Then yeah, that's going to be a best interest decision, that's fine, okay? But obviously a record of it.
I think the key to that though is, have you actually documented capacity test?
Yeah.
Because people launch into an MDT discussion call it the best interest meeting, but don't have the precursor of, does this person lack capacity? And that's the bit that I think sometimes is missing.
Yeah, so I think obviously before you've got to a best interest stage, you want to be able to demonstrate that you've got the. I know that record's going to be beautiful. Okay, so I can take some questions at the end, and I'm hanging about as well. So if you want to come up and have a chat with me about a particular case or whatever, feel free to do so. So we have the interrelationship between the Mental Health Act and the Mental Capacity Act. Probably, along with the interrelationship between social care and healthcare, probably the most troubling issue in law for those who advise in the healthcare sector. Basically, the House of Lords Select Committee has said that it challenges even the most astute and knowledgeable, and I'm now to advise. So there's a new Mental Health Act Code of Practice just released in January of this year. Usually, whenever you're dealing with someone who may lack capacity, may fall to be considered under the Mental Health Act, usually only one regime is applicable to that person. Okay, so normally they are mutually exclusive, but sometimes both the Mental Health Act might apply and the Mental Capacity Act may apply. Okay, it's always important, and it is quite a difficult area to advise on sometimes. So if you do find yourself in one of those scenarios, it may be worthwhile speaking to whichever legal advisor you have access to. It is always important to remember that someone sectioned under the Mental Health Act may still have capacity to consent, particularly to physical treatment. Okay, so it just shouldn't be presumed that just because they're sectioned they don't have capacity to consent to physical treatment, unless it's connected to the mental health condition. So this is an example of just how difficult it can be in some circumstances. So V had borderline personality disorder. She has swallowed razor blades and was refusing treatment, saying she wants to die. The doctors feel she may well have capacity to make the decision as to whether or not to accept that treatment. So therefore the Mental Capacity Act isn't applicable. It's not available, because if someone's assessed as having capacity, then that's it. Mental Capacity Act doesn't apply, no jurisdiction. She needed physical treatment, so the Mental Health Act wouldn't normally apply, but the court determined that there was sufficient connection between physical treatment and the mental health condition in order to allow her to be compulsorily treated under the Mental Health Act for what ostensibly looked like physical treatment. But the court said that actually the two are so bound up together that she could be compulsorily treated under the Mental Health Act for this particular treatment. But there are so many grey areas and so many things that can go wrong in those circumstances that it's very important that you do remember the distinction between mental health and mental capacity. It often happens whenever you're dealing with someone who's presenting with suicidal thoughts or tendencies. Okay, so that's all being well. Everybody knows capacity, everybody knows best interest, everybody's records are beautiful, up to date and excellent. So there shouldn't be any disputes, but sometimes there are. So the Court of Protection is the forum for resolving disputes for people who lack capacity. Okay? Might sound very straightforward, but actually the Court of Protection only has jurisdiction to deal with those people who lack capacity. If somebody's shown to have capacity, this court doesn't have any jurisdiction to deal with them. It's also important to remember that the Court of Protection only has the ability to make decisions that that person would have the ability to make. Okay? And what I mean by that is it comes up very often in something along the lines of do not attempt resuscitation cases, where if the clinical team had decided that the person, it would be futile to attempt CPR on that person, and that person lacks capacity, sometimes the clinical team then think, oh well, we need to make a best interest decision as to whether or not it's in their best interest to have CPR. Well, no. If the clinical team are saying that it's not, that it would be futile to engage in that, then the court nor anybody else can compel that clinician to give that futile treatment. So the question you just ask yourself is, well, would I give this treatment to someone who had capacity? Would I feel compelled to give that to somebody who had capacity to decide that issue? Well, no, because it's futile, Well, the Mental Capacity Act doesn't impose any greater obligation on the clinician, or indeed it doesn't give the court the right to say to that clinician, you must carry out CPR on that person. Okay? So it's important that you remember that the Code of Protection, it declares things, so it says what's in somebody's best interest. It declares, does somebody have capacity, yes or no? It declares what might be in the person's best interest, but it cannot tell a doctor to do something. It can't say the doctor must do this. Obviously, if a court says that it's in somebody's best interest to continue receiving certain types of treatment, then you would tread carefully before saying that we as a trust, etc., are going to refuse to provide that. But ultimately, the court cannot order doctors to do things. Certainly not the Code of Protection. Okay, well, the Code of Protection gets a bad rap sometimes. So here we have kidney failure patient is forced to have dialysis, is the report. And this is a particular case that was received a lot of adverse media publicity regarding the Code of Protection. A 55-year-old suffering from advanced cancer of the uterus, hysterectomy indicated, alternative is spread and death. Okay, so that's the choice that's facing that person. The person lacks capacity to be able to make that decision for themselves. So ordinarily, as a clinician, you would sit down, talk over the issues with them, and then say, well, do you understand the risks of either proceeding or not proceeding with the treatment? There's a significant impairment of the intellectual function. As a consequence, didn't have capacity to make decisions on any of the healthcare issues involved. There was consideration about best interest. You can imagine how that conversation goes. An incredibly difficult best interest decision to take. The reason being is that this particular patient had a massive phobia of hospital, and so simply could not be brought to the hospital. And the very unenviable situation is going to have to be envisaged whereby she was going to have to be sedated without her knowledge, and then brought to the hospital to have the operation, and then brought back afterwards. So you can see how, in terms of a best interest decision, how difficult that's going to be. The clinicians wisely decided that they weren't going to run that particular risk themselves. And one of the key things that the head of the Code of Protection has often said is the Code of Protection is a forum for risk sharing. It's an opportunity for those sorts of cases like this one, where there doesn't really appear to be an ideal way to resolve it, to then bring it to court and ask the court to take a decision, ask the court to share the risk, rather than have the hospital just make one decision one way or the other and end up being severely criticised, whichever way it jumped. So it was brought to the Code of Protection, and permission was obtained not only to operate but to take necessary steps to sedate and restrain post-operatively. So quite a difficult best interest decision. Obviously, it did engage this lady's human rights in terms of Articles 5 and 8, the right to private and family life and the right not to be deprived of their liberty. But the court said that it was necessary and proportionate in order to carry out these acts because they were in their best interest, and there was no less restrictive way of doing it. It looked at other options, but there was no less restrictive way. So that should show you the sorts of things that the Court of Protection is grappling with. Okay, this is how it often gets reported. So cancer patient forced by a judge to have surgery, normally as well, secret court, etc., etc. But that's essentially the sorts of decisions that we deal with on a weekly and monthly basis with the Code of Protection, and the sorts of cases that you might well find you become involved in yourself. So the three key messages. Remember, capacity is time and decision specific. Don't just think lacks capacity. I mean, that's going to get a serious eye roll from me if any of your notes ever end up on my desk. Capacity to do what? Okay, to decide what. Refer to the test with the 4 limbs, understand, retain, weigh, communicate. And have you done everything, not everything, have you done everything practicable, okay, to help people make the decision for themselves? Okay, so that's basically a running for what capacity, best interest, and Code of Protection are involved in. the last thing I'm really going to talk about is deprivation of liberty. I'm going to do it relatively briefly, I think. Otherwise I break my promise to do it within 45-50 minutes. So the meaning of deprivation of liberty is now subject to what's called an acid test by Lady Hale in the Supreme Court decision of Cheshire West. Okay? What it means is, so it used to be lots of things to think about, but the only thing you need to ask yourself now when asking, is this person deprived of their liberty? So you pop out to a care home, you go and see a patient in a care home, and you ask yourself, is this person deprived of their liberty? What question do I ask? Well, you ask, is this person under continuous supervision and control, and are they not free to leave? If the answer to both of those is yes, they are deprived of their liberty under Article 5 of the European Convention of Human Rights. What does not free to leave mean? Well, continuous supervision and control, I think we can all agree what that probably means. Not free to leave doesn't mean that they get up and try to leave and are stopped. What it means is, if they tried to get up and leave, would they be stopped? Or if a family member, for example, came along, would have put them in a wheelchair and about to wheel them out the front door, would they be stopped? So it's not their physical ability to leave, it is if they were to try and leave, or if someone were to try and remove them, would they be stopped? And if the answer to that is yes, and they're under continuous supervision and control, then they are deprived of their liberty for the purposes of Article 5 of the European Convention of Human Rights. Okay? So, if someone is deprived of their liberty, it's not lawful unless it's under a deprivation of liberty safeguard, which is granted by a local authority, a court of protection order, so you've gone to the court of protection, or it's necessary for life-sustaining treatment, or a vital act whilst the decision is sought in the court. And that last one is a very, very little sliver of light that is open to clinicians, which is to say that what should never happen is that a clinician decides, well, I'm not going to provide life-sustaining treatment unless the court tells me it's okay to do so. The law recognises that a clinician can go ahead and provide life-sustaining treatment even where it amounts to a deprivation of somebody's liberty, so long as that hospital or that organisation is making an application to the court contemporaneously with the provision of that treatment. So the important thing to remember here is that the deprivation of liberty definition now probably covers, the vast majority of people with severe dementia in care homes now, and it probably covers a heck of a lot of the 1.5 million people with learning difficulties who are living in supported living. So if you then say continuous supervision and control and not free to leave, and by not free to leave, remember, means that not that they are trying to leave and being stopped, but that if they were to try to, would they be stopped? Then it's catching a whole lot more people than was previously the case. Okay? If you're in a care home or in a hospital, then the local authority, as the supervisory body, can grant a DALS authorisation, deprivation of liberty safeguard standard authorisation. If it's in the community, however, DALS can't be used, and therefore any deprivation of liberty in the community can only be authorised as being lawful by the court of protection. Okay? And there's a new process that's been set up to try and speed that up a little bit. So those are the only circumstances in which deprivations of liberty are going to be lawful. Okay. What's not relevant? Well, the Court of Appeal, in relation to all three cases in Cheshire West, had said that it didn't amount to a deprivation of liberty, because these three people were living in community placements. It was agreed that everything was in their best interest, that they were receiving excellent care, and it was also agreed that actually if they'd been allowed to walk out the front door, then actually the authorities in question would be negligent. But that still amounted to continuous supervision and control and not free to leave, and therefore a deprivation of liberty. And Lady Hale said that the relative normality of the placement is irrelevant. So just because someone with this level of disability would find this particular placement relatively normal, that's irrelevant. She said people with disabilities are entitled to the same right to liberty as everybody else. So you can't discriminate based on disability. Compliance is irrelevant. The fact that somebody is compliant is irrelevant to whether they're being deprived of their liberty. So it used to be that it would only really have been considered suitable for a deprivation of liberty safeguard if someone was trying to go out the door or trying to abscond, etc., well, no longer. Compliance is completely irrelevant. The quality or the appropriateness of the care is irrelevant. Obviously, it's good that someone's receiving good quality care, but it's not relevant to consideration of whether they have been deprived of their liberty. Nor is the purpose of the placement relevant. So just because it's a benevolent placement that's in their best interest and actually probably the best place for them to be, that doesn't render it any less a deprivation of liberty. And in a very famous phrase, Lady Hale has said that a gilded cage is still a cage, and therefore it's a deprivation of liberty. I'll not take the questions just yet. I've been asked to discuss one other issue, which has come up quite often now, which is deprivation of liberty and when somebody passes away, and what to do with coroners. So the first thing to think about is that under the legislation that the coroners deal with, if someone is considered to be otherwise in state detention, which sounds very ominous, but otherwise in state detention, then it gives the obligation on the coroner to carry out an investigation. So not an inquest, but an investigation. The rules then say that if somebody is in state detention, the coroner doesn't have the usual thing that he or she can do by discontinuing the investigation. So normally, even if a coroner has to conduct an investigation, a coroner can say, well, I'm not going to investigate any further. I'm going to discontinue it, i.e. no inquest. But the chief coroner has said no. Where somebody is subject to a deprivation of liberty safeguard at all, then there is a requirement to carry out an inquest. There is a requirement to notify the coroner. The coroner has also said that actually, where someone has been in a care home and is deprived of their liberty in a care home under a DOL and is transported to a hospital, then in those circumstances the deprivation of liberty and the state detention still applies. There would be an obligation to inform the coroner even in those circumstances as well. Okay? So even where the person has passed away in the hospital and not in the care home where the deprivation of liberty safeguard relates, in those circumstances there's still an obligation to inform the coroner. The coroner has said, the chief coroner has said that given the fact that there's going to be a whole lot more people who are considered to be deprived of their liberty, and I think that the ADAS, the Adult Director of Social Services Organisation, have said that actually it's going to go from 13,000 applications last year for deprivation of liberty safeguards to 130,000 this year. That in those circumstances there's obviously going to be a lot more people who are going to be passing away under DOLs. As a solution, the chief coroner has said that most of these inquests that need to be carried out can be done on paper without calling witnesses, and that therefore it's important that local authority deprivation of liberty leads, and indeed some people involved in safeguarding as well, should be liaising with their individual coroners in order to see what that coroner wants to do. There are circumstances in which local protocols are being worked out, etc., and it's best to try and keep abreast of those. What the chief coroner has said is that this is only guidance. He is only given this as an outline of his view, and the High Court might well make a different decision in due course in all of this. I do understand that Gillian has told me that the CCG is working on a flow chart for all of these issues, and that will be distributed and should help and assist with these issues about when and how to make reference to the coroner where someone has passed away subject to a deprivation of liberty safeguard. The last point I want to make on this is that the chief coroner has said that the DOL needs to be in place before there is a duty to report it. Now obviously that's a very odd scenario where, either somebody's just missed it and somebody's unlawfully in the community without having a deprivation of liberty safeguard, or somebody's in a care home without a deprivation of liberty safeguard. That person doesn't need to have their death reported to the coroner in the normal course of events, whereas if somebody is under a DOL, they do. Doesn't make a lot of sense to me, but that's what the chief coroner has said. That might well change, I suspect. I think that might well be clarified. But as things stand, the guidance does say, unless the DOL is actually authorised, so there is a standard authorisation, then there is no obligation to report that or for the coroner to conduct the investigation. From your perspective, I would simply encourage you just to inform the coroner of those circumstances that a safeguard's been requested but hasn't been received, and leave it to the coroner. Okay? Does anybody have any questions or no? Oh, you've got it.
So sorry, me again.
Yeah.
Can I just check? If tomorrow I had to go to a care home
Yeah.
and someone died who was under adults, I have to ring the coroner.
Yeah. Okay. Sorry?
You said in your presentation that you found the majority of the patients with severe dementia who were in care homes should have a doll in place. That's certainly not the case at the moment.
Yeah.
Do you think that's going to change? And if so, there are tremendous cost and resource implications with that. And has the government taken that into consideration?
On the latter point, I don't think Lady Hale had that foremost in her mind when she came up with her acid test, no. But yes, it has huge resource implications. The first point is the vast majority of people who are under continuous supervision and control and not free to leave, including severe dementia patients, will require a deprivation of liberty safeguard. There is a new process that's been adopted by the court called a REACT process, which is actually being dealt with today. But it's been live since November, and it's a much more streamlined process for making applications, i.e. there's no hearing, it's just done on paper, etc., etc. But that doesn't lessen, frankly, the court process for those deprivation of liberty safeguards in the community. The only thing I could say to that is that the local authorities are aware of the increased requirements on managing authorities to make those referrals. They are trying to add extra resource, but obviously there's a huge backlog and a huge difficulty in dealing with them all. So,
I think the other issue that this raises is, as with child protection, the ability for the local authority to communicate with those of us in primary care is somewhat lacking, I think is probably the right term. Is there any statutory requirement for the local authority or the place where somebody resides in Nichols to provide information to carers that is actually in place?
Well, there is, as we just discussed, so if someone is assessed as lacking capacity, then there's obviously a duty to consult with carers, etc., etc. There is a legal obligation on a managing authority as a care home to make the application to the supervisory body to have that person's deprivation of liberty authorised where they've identified that it amounts to deprivation of liberty. So the managing authority does have an obligation to let the supervisory body, to make the supervisory body aware of that. As to whether or not there's a specific statutory obligation to consult those in primary care, no. There's no specific statutory obligation to do that. There is an obligation, a general obligation to facilitate between health and social care that flows both ways, although it's expressed in very general terms, so as to whether or not that's going to lead to you receiving more information than you're currently receiving, I don't know.
Because I suspect there are going to be numerous occasions where patients actually have adults in place, but we're totally unaware of it. So when they die, we won't refer them because we don't know.
Yeah, I can envisage circumstances in which that will probably happen.
Just got one question. I was actually involved with this.
Okay.
This very scenario in the sense that one of our patients died in a residential nursing home, had a dose order in place. Had to inform the coroner's office about this. And the way around this, I was told by them, it might be a temporary situation, was that I was supposed to write a quick letter addressed to the coroner's office stating that I'd been looking after this patient, I'd been supervising this patient until she died, and that if I were in a position of writing a death certificate, I would have put 1A dementia to this. And that was then sent to the coroner's office, and they would then use that as a means of perhaps not going down the route of a post-mortem.
I think that is an approach that's been adopted by some coroners, which is to say, I mean, if you think of it in the purely legal process that happened there, well, you're aware that somebody's passed away under a doll. You've notified the coroner that they passed away under the doll. The coroner is then under an obligation to conduct an investigation. The coroner is treating your letter or the information you provided as being sufficient information for then the coroner to say, I've held an inquest and I've seen no need for a post-mortem examination, I see no need for witnesses, that's fine. You see, so some of them are adopting that process, and it is worthwhile trying to speak to whoever's dealing with the local coroner's court to see what their approach is, and it will be different from one coroner to the next, I can say that.
Could I just add to your question, we are working with the local authority who hold the contract with the care homes, that they have an obligation when a patient dies and is under a DOLS to inform the GP before they sign the death certificate. So if that is not happening, I want to know about it because they're breach of contract. But I need specific examples.